Hey patent friends, welcome back to another video. I'm going to discuss today how you keep ideas and inventions safe. And of course that's going to be through patents, and I'll kind of give you the basis of how to protect ideas and inventions with patents, but almost more importantly, and probably where a lot of you folks are now, is how to protect your ideas and inventions before you file a patent application, because it's really easy to unknowingly forfeit your patent rights by doing certain things and making certain mistakes, and those are the things you want to avoid. So stick around, we are starting right now. So for those of you who are new here, my name is Dylan Adams. I am a patent attorney and author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit with Marcus Lemonis. So this channel is all about giving you the insider secrets of how I help my clients, whether they be Fortune 100 companies, individual garage inventors, or startups, protect their ideas and inventions and make them successful. So be sure to subscribe to the channel, hit that little bell icon so you don't miss any important videos, because we got a lot of great content. All right, let's go ahead and get right into it. So how do you keep your invention idea safe? And obviously, filing a patent application, that's a great way to protect your ideas and inventions because it gets you a filing date and gives you priority over that. But like I said, that's probably not where most of you folks are. You have an idea, it's in the early stages, and you don't have the ability or you're not ready to file a patent application. So how do you protect your invention ideas before you file a patent application? This is actually really critical because I deal with a lot of folks who come to me and they have already forfeited their patent rights. They cannot file a patent application because they've had activities that forfeit their patent rights, and that even if they were to file a patent application, their patent would be invalid. Okay, so this is what's really important. So it's three main things that start forfeiting patent rights. So it's public disclosures, public uses, and offers for sale. They begin to forfeit patent rights. Okay, and again, public disclosures, public uses, and offers for sale start to forfeit patent rights. In foreign jurisdictions, like pretty much any country outside of the United States, you automatically forfeit patent rights upon a first public disclosure, public use, or offer for sale. In the United States, you have 1 year from a first public disclosure, public use, or offer for sale to file a patent application. Otherwise, you lose your rights. Now, this may make you think, well, okay, whatever, I'll just start doing these things. And in the United States, I'm not thinking about foreign protection, so who really cares? I'll just, use that 1 year buffer in the United States, and then I'll file my patent application. That's totally fine. That's not really a good way to go. And here's why. It's because, a lot of times if you're looking to attract investors, you may not be thinking about foreign stuff. And honestly, you do not want to file a foreign patent application yourself. They're absurdly expensive and not a great idea for a lot of companies, especially startups and individuals. But when it comes to certain investors, that may be critical for them. For instance, they may say, hey, I have partnerships in Germany and Belgium, and that's going to be a major market because I'm going to have major market penetration there, and I hope you preserved foreign rights. And if you say, oh, well, I didn't think those were going to be important jurisdictions, I started making public disclosures, public uses, or offers for sale, and forfeited my patent rights, you're going to lose that investor. And I've seen a lot of folks do that where they say, whatever, we didn't care about that. We didn't need to forfeit patent rights, and then come back to me and say, hey, so we got this investor, and Australia and Canada and China are really important jurisdictions to them. Is there a way to now file patent applications there? And it's like, well, no, sorry. You made public disclosures, public use, or offers for sale, and you forfeited your foreign rights. So the best practice is to, again, file at least a provisional patent application before you start making public disclosures, public uses, or offers for sale. Now let's kind of tease out those three things because that's really important to do and understand kind of what those things are. So public disclosure, it has to be something that is public. And it doesn't necessarily have to be something where people actually see it or there's proof that somebody saw it. So if you have a blog post, and even if maybe even you could prove that there was no website traffic from outside people, it was only me, I was the only person who looked at it. That does not matter. As long as it's a public disclosure that people could access, that's sufficient to forfeit patent rights, at least in the United States, after 1 year. Some foreign jurisdictions are a little bit different about what they define as being public, but that's a good way to think about it, is if it's accessible to public, that's a public disclosure. So putting something up, pictures of your invention on social media or on a website, or displaying it at a conference or something, that's not what you want to do. Those are public disclosures, okay? But what about, say, talking to your friends or family? As long as there's implied confidentiality, then it's not going to be a public disclosure, okay? So, there are some limits, but at the same time, you want to be very careful with those things. So that's public disclosures. Public uses is, if you use it in public, and even if it's used sort of in a hidden kind of way, that can potentially forfeit patent rights. Even if, there's a good example, and this is one that I have in my book, so there was a woman who invented these corset springs, and she wore them out, she gave them to her friends, and they all wore them in public, and you couldn't see the corset springs, right? They were sort of hidden in the corset and under these women's dresses, but the patent office found that was still a public use, because even though it wasn't observable, it was still public, even though you couldn't see it, and that forfeited her patent rights. So that's public disclosures. And when it comes to public uses and public disclosures, talk to a patent attorney. A lot of times it can be free or super cheap to kind of talk through these issues and say, hey, is this acceptable? Is it not? Based on the current law, things like that. Okay. Now, the third thing, offers for sale. It's important to understand it's offers for sale. It's not like you have to actually make a sale. If you have an offer for sale, say like on a website saying, hey, come and buy this product, it's only $200. And even if you can't actually fulfill those orders, just offering something for sale, that can forfeit your patent rights as well. So you want to avoid those things. Okay, so like I said, you want to file a provisional patent application before you make public disclosures, public uses, or offers for sale. Another reason why people want to file patent applications typically is when they're starting to approach investors. And approaching investors, as long as it's done with at least implied confidentiality, then you're going to be fine. So like, well, okay, why would you want to do that? Well, when approaching investors, it's good to be able to say you're patent pending. It's going to help your pitch. It makes them take your technology more seriously, and it creates some value for the company. You have a patent portfolio that's pending. It's going to make it better for you. Also, it allows you to go and talk about things freely because you filed your patent application. You have a priority date, and so that person then can't go and theoretically file a patent application on what you're doing and try to get priority over that. Or theoretically, if they were to go out and try to steal your idea, you have rights that would annodate when they started doing that. If you got an issued patent, you'd be able to have priority over what they were doing. So it allows you to talk freely with folks. And for those of you who are in the startup community, you do not want to ask investors or other folks to sign NDAs. They're going to be insulted. They're going to peg you as a newbie, and they're probably just going to give you a friendly no and have you go on your way. So it's a great way to not have to deal with that whole non-disclosure issue or having to be kind of cagey about what you're doing. File your provisional patent application and talk to investors. You can talk freely, and it allows you to be able to increase the value of your pitch and your company. Okay. So that's public disclosures, public use, offers for sale, talking to investors. But then there's the timing of when you file patent applications, right? You typically want to file right before those things happen, okay? And it's kind of counterintuitive because the United States is a first to file country, all right? Just like the rest of the world, where you get priority based on when you file your patent application. If you file your patent application and then somebody else, say like they invented earlier than you get priority because you filed first, even if somebody else invented first. Okay, so that's important to know, and that would make you think, okay, well, we need to file our patent application as soon as possible. That's really important. Let's get this rolling. But that's not a great from a business standpoint. Sure, it gives you early priority over things, but it doesn't really help set up your company for success. And here's why: is because, like I said, the way to start the patent process, especially for startups, and I have some great videos on this to talk about this in more detail, but is to file what is called a provisional patent application. The provisional patent application, again, it's just a placeholder, only lasts for 1 year. It expires at the end of that year, and then you have to file the expensive non-provisional patent application. And that is one that, if you're going to be smart about it, you're going to have an attorney draft and file that application. And that a lot of times that can be over $10,000 to draft and file. It's not a cheap thing to do. Sure, you can kind of do, you could potentially do it yourself or find some kind of cut rate folks to help you out with that. But it's going to be expensive. Even if you have sort of, cheap patent agents or patent attorneys doing things, it's an expensive proposition. So waiting to file your first provisional application is good because it delays the time when you have to file that non-provisional patent application, okay? Because it sort of, locks you into this timeline of cost, and, your company needs to preserve those fees. Startups do not want to be spending their money on extra IP stuff unless they absolutely have to. So that's why it's good to delay filing that provisional patent application until you're close to making a public disclosure, public user offer for sale, or before approaching investors. Okay, so that is the best way to protect your invention ideas before you file a patent application. And once you file a patent application, then you'll be patent pending, okay? Whether you file a provisional patent application or if you were to start with the non-provisional, which is really only what large companies do. For pretty much any small company, I recommend filing a provisional patent application first. Both of the provisional versus non-provisional, they give you patent pending status. So you'll be patent pending from when you file the provisional till you file the non-provisional, while it's waiting for examination, once examination begins. And then the only time when you're not patent pending is when that application has issued as a patent. Then you go from being patent pending to patented, having an issued patent. Or if, for instance, you run out of money, or if you can't get over prior rejections during the examination, and you have to let the application go abandoned, and then the application dies, and then you're not patent pending anymore, okay? So those are the ways that you can protect your invention ideas. If you got some value out of this video, please give it a thumbs up. I would really appreciate it. It helps the channel out. And if you want more content related to patents and startups and the insider information on how you can be successful when it comes to IP strategy and patent strategy, be sure to subscribe, hit that little bell icon so you don't miss any important videos. And thanks for watching. We'll see you again in the next video. Thanks.